What if a property settlement can't be reached?
Well, one party will need to file an application for property settlement with the court. Now that could be either the Federal Circuit Court or the Family Court. For the purpose of this example, I'll assume it's the Federal Circuit Court. So you need to prepare 3 documents. The first one is called an application, and that sets out the orders that you are asking the court to make. The second document is a financial statement, which sets out your current financial circumstances. The third document is an affidavit. Now, an affidavit sets out the evidence that you want the judge to know about. Now, when the court receives the documents, they will allocate a date for the first day in court, which will usually be about 6 to 8 weeks away. So prior to then, you need to serve the documents on your partner.
What does the other person have to do before the first court date?
They also have to file their documents with the court. They have 3 documents to prepare as well. A response, which sets out the orders that they are seeking, a financial statement, and an affidavit.
What happens at the first court date?
The judge determines whether the matter is ready to go to the next stage, which is a conciliation conference. If it is, then the judge will allocate a date for the conciliation conference. If it's not ready to go to the conciliation conference, the judge will make orders so that the matter will be ready. That may mean making orders for valuations or disclosure of information. In that case, the judge will usually order that the matter come back before them in a couple of months' time to make sure that everything has been done, and when it has, they will then order the conciliation conference date.
What happens at the conciliation conference?
The parties and their lawyers meet with a court registrar in their office. Usually the court allocates 2 hours, and the aim is to try and come to an agreement. If an agreement is reached, then it will usually be drawn up at the conciliation conference, signed by everybody, and orders made. If an agreement is not reached, then the matter will go back before the judge, who will allocate a hearing date and order the matter to be prepared for the hearing.
And what is involved in preparing the case for trial?
The major part is getting together the affidavit evidence of the parties and their witnesses, and possibly also valuations of assets.
What happens at the trial?
A trial usually runs from 1 to 3 days, depending on the complexity of the case. Now, everybody gives evidence on their affidavits, so the major part of the trial is the other party's lawyers asking you questions about the evidence that you have given. At the end of the trial, you don't normally get a decision on the spot. Usually it's a number of weeks or sometimes months before the judge issues their judgment.